Good evening. On behalf of Take Back the Night and the Date Rape Peer Education and Outreach, I'd like to welcome you to this evening's event. And welcome to the IOP. I'd also like to encourage you all to attend Take Back the Night's rally, which will be tomorrow evening at 7:30 p.m. in the quad behind the MAC Athletic Center. And right now I'd like to welcome Ellen Fitzpatrick, who will be introducing Linda Fairstein. Thank you very much.
Thank you. I'm very happy to have this task tonight, which is not a task but a pleasure. About 20 years ago, Elizabeth Cady Stanton, the wonderful pioneering feminist of the 19th century, gave a talk about sexual violence before a women's temperance association. And in the talk, she made the comment that, quote, personal liberty in the true order comes before political freedom. And she was trying to stress the ways in which issues of domestic violence and sexual violence for women needed to be addressed by the emerging feminist movement, that it was not enough to simply win voting rights or to have property rights, but that there had to be a sense of security and safety, a sense of personal liberty that women felt before they could really be truly liberated politically or in any other way. And I think it was a very profound observation on her part. And alas, it's an issue that we're all still struggling with these many years later. Our guest tonight, Linda Fairstein, has been extremely important in this long battle that women have waged to claim their personal liberty and a sense of personal safety. She has been a very important spokeswoman on the issue of sexual violence. And as you all know, she has prosecuted a number of very famous or infamous cases and been extremely effective in doing so. She is the chief of the Sex Crimes Prosecution Unit in Manhattan, and has been very effective in that position. Prior to that time, she served as the deputy chief in the trial division. She's a graduate of Vassar, so carrying on this tradition of the women's colleges producing women leaders. And of course, Elizabeth Cady Stanton would be thrilled about that if she could be living all these many years later to see the fight going on. She's also written a very compelling book called Sexual Violence. I'm not working for the publisher, but I do want to call your attention to it because as I read this book, I was very struck by the mix of kind of personal anecdotes, case studies essentially, or case reports, Linda's own experience and development as an attorney dealing with the issue of sexual violence, and the larger political issues that I assume all of you are interested in, or you wouldn't be here tonight. It seems to me that the whole story of sexual violence has been a story about women who have had the courage to come forward and to speak, to really stand up front and to pursue justice, both for themselves and for other women, as Linda has done, and have had the ability. Saul Alinsky once said that this was the very definition of a radical. It was someone who could turn personal problems into public issues. And it was when women began to see that what happened to them individually had a larger meaning that issues of sexual violence really began to be an important matter to the women's movement. That dates back all too long ago. But our guest tonight certainly deserves some of your praise and attention for all the work she's done to advance attention to this issue. Thanks. Linda Fairstein.
Thank you. And thank you, Ellen, for that very generous introduction. I always think it should be a very short introduction since I have only had one job in my professional lifetime. But it was my good fortune to come to the practice of law at exactly the moment that laws all across this country began to change in the field of criminal law that became my specialty. New York, which many people think of as a very progressive state, is actually one of the worst states for law reform and one of the slowest, and one of the states in which still a lot of work needs to be done in this area. But when I joined the office of the district attorney in 1972, my only professional interest in that time was in becoming a public servant, in doing public service and becoming a prosecutor in the office of a man who was Frank Hogan, who'd been district attorney then in Manhattan for about 28 years when I applied to the office. There was not a sex crimes unit anywhere in this country, nor any prosecutor who specialized in the investigation and prosecution of these crimes. So my goal was not to go into this kind of work and to become involved in work on behalf of women or women's issues, as many young women choose to do today in a variety of legal pursuits. I wanted to prosecute, and Frank Hogan had what was then considered the best district attorney's office in the country. He had changed what had been a very usually politically driven position into what he considered merit appointments for young lawyers. And the problem at that time when I applied to the office was that there were 160 lawyers on Mr. Hogan's staff, only 6 of whom were women. And he told me, as he told every other woman he interviewed during that process, that the work was too tawdry for women, that was the word he used, and he didn't think it appropriate for us to do that kind of work. Fortunately, Bob Morgenthau, who became DA in 1975, recognized in me the qualities that would thrive on tawdriness, and I have been very happy in that office. The good news is that there are now 600 assistant district attorneys in Manhattan, for those of you who are pre-law and interested in public service. There are another 600 in Brooklyn and 300 in the Bronx and a couple hundred in Queens and 24 in Staten Island. But half of the lawyers in our office now are women. When I went to that office in 1972, no woman had ever tried a murder case in New York State as a prosecutor. We were simply not allowed to do trial work. Only 2 of the 6 women in the office were even in the trial division. We were supposed to be doing the appellate work or practicing in the grand jury, but not in court before trial juries. So it's been wonderful to be part of that extraordinary change in my professional lifetime. Another aspect of sexual violence at that point in time was the fact that there was very little responsible media attention to these issues. If you go back and look through old copies of the New York Times, you will see very, very few stories about sexual assault. And in fact, when my colleagues and I began to try rape cases, the court reporter who's assigned to the criminal court building from the New York Times wasn't allowed to come to our trials because he told us that Times readers, according to the editors, simply weren't interested in reading about these cases, and so they would not be followed. But there was a story the year before I joined the office in the Times, one of the rare stories, as I said, that they saw fit to print about rape, in which they noted the statistic that the year before I joined the office, more than 1,000 men were arrested in New York City, in the 5 counties of New York City, that year for rape, and only 18 of them were convicted of the crime. Now, in each of the 5 counties, hundreds of individuals are convicted of rape and other forms of sexual assault every year. These enormous changes are the result of the legislative reform that has been accomplished within the 2 decades that I've had the pleasure of being in that office, and also because of the very creative and unique programs that were undertaken in the police department and the prosecutor's offices throughout the city to identify the problems that are really unique to the investigation of these cases and to be creative about making better cases. The reason that I decided to write the book, I was actually asked to write it in 1986, and it's the only thing that I have ever done, for all those of you whose parents have told you not to procrastinate, it's the only time that procrastination has ever paid off for me, because I was supposed to finish it by 1988, and between the time I agreed to do it and the time it was delivered 6 months ago, 8 months ago, has become even more timely and topical. But I, shortly after agreeing to do it, undertook the prosecution of Robert Chambers, and then was involved in the Jogger case, which my colleague and friend Elizabeth Lederer actually tried. But I put it off for all those years and didn't start writing it again until '91. And it's been very rewarding for me because there is a much greater interest in this subject across the country now than there was in 1988. But the reason that I agreed to write the book was that as I travel around the country and train other prosecutors and police agencies, one of the most troubling aspects of the work is that public attitudes about this crime and the ideas that most people have about victims' ability to prosecute in these cases are really still greatly populated by myths and misconceptions. And there is very little sense of the real progress that has been accomplished in this field and of the extraordinary changes that have taken place in 2 decades. The book is not a polemic, but it's very accessible, practical stories about changes in the law, but illustrated by cases that we have worked on that show the great range and variety of these crimes. When I started to do this work, and I'm not going to make you legal scholars in this short time this evening, but I think it's really important to understand the historical development of the laws in this country, because it's really what is I think the most significant factor in the change that's occurred and what has allowed us to make so much progress in this field. When I joined the Office of the District Attorney, I don't know what I'm standing on here, but I feel like it's going to open up and send me down to the basement, which it may. At the time I started prosecuting these cases, New York was one of the last states in the country to still have what is called a corroboration requirement. And that's a legal term which very simply meant that the word of a woman reporting a crime of sexual assault was not legally competent, was not sufficient to allow her to go into court and tell her story to a jury, as it would the word of any other victim of any other violent crime. And so the law mandated that the testimony of a victim in a rape case had to be supported by independent evidence beyond the story that she told to the police and prosecutor. And the law was very specific about which 3 elements of the crime had to be proved by something beyond the victim's word. First was the identification of her assailant, which had to be proved by somebody else. There are many crimes in my city and yours and most other places around this country that occur in broad daylight with a lot of witnesses. What's going on here? There are bank robberies and muggings and, sadly, murders in our cities every day that happen in front of a lot of eyewitnesses. Rape, as you are well aware, rarely has any witnesses to the crime, and yet the law required that someone see the victim with her assailant either immediately before the occurrence of the crime, or as he was leaving the crime scene, or during the act itself, which barred the overwhelming number of victims from being able to go forward. The second element that had to be proved independently was the sexual nature of the attack, so that the woman couldn't say that she had been penetrated by the offender. There had to be, it was usually medical evidence, to support that the assailant had penetrated. And as we have been very slow to learn, many offenders don't complete their acts. That's not a requirement of the crime, and many are sexually dysfunctional. And yet, literally, there had to be something like seminal fluid in the victim's body in order for that element, the sexual nature of the crime, to be proved beyond her word. And third was the element of force, which meant that if an offender had displayed a gun or a knife and threatened the life of the victim, or threatened her life verbally, and she wisely submitted, didn't resist her attacker, and he wasn't caught that night with the weapon leaving the crime scene, then she was not competent to tell a jury that he had been armed. Literally had to recover that weapon from him to be able to display it to the jury to prove that she had simply not consented to this act. And it wasn't one of those 3 elements that had to be proved independently. All 3, identification, the sexual nature of the attack, and force, had to be met, had to be proved by independent evidence before that victim could set foot in a courtroom. And rape, of course, was the only crime that required this this corroborating element. I would meet women when I started to do this work by 1974. I would meet women every day of the week who would testify, for example, to leaving an office building on Fifth Avenue in Manhattan at 11 o'clock at night, and a woman might say, an assailant I'd never seen before confronted me, held a gun, demanded my money. She said I would give my watch and my money to the man, and then he said, go back in the building, take your clothes off. He raped me in the stairwell of the building. She was legally competent to tell the jury about the robbery by identifying the man in the lineup, whether or not the gun was recovered, whether or not he had her money. But she couldn't tell about the rape at the same time unless those three elements were corroborated. She was simply not allowed to do it. So those 18 convictions that we had the year before I joined the office, it wasn't that we were trying and losing the other cases. The other women were not allowed to have a day in court as recently as 1974 in New York State. To me, the most interesting part of that law is the historical basis for the corroboration requirement. There was a jurist in England, Sir Matthew Hale, who wrote, he was Lord Chief Justice of the King's Bench, and he wrote a great many opinions about violent crime. And several of them, unfortunately, were about sexual assault. The opinion for which he is most famous, because it's been paraphrased in this country, still is paraphrased in courtrooms in this country, is the one that is colloquially spoken as, because rape is a charge that is so easy for a woman to make, but so difficult to a man to defend himself against because it's so inflammatory and so prejudicial, we must examine the testimony of a rape victim with more caution than we do the testimony of any other crime victim. That expression of examine with more caution became the corroboration requirement. Unfortunately, that case opinion was written in the year 1671. And yet it was incorporated in the laws of almost every state in this country as we began to develop our criminal laws and criminal procedure laws. And so it took 3 centuries in New York for the legislators to move to eliminate that very archaic requirement. Hale's, among his other opinions, were things that played a part in the laws in most other states as well. He wrote that it was much more important, for example, if the victim of a rape was a virgin than a previously unchaste woman, because a previously unchaste woman was presumed to be the property of her husband, and it was a much more serious crime. If he couldn't control his wife, well, that was unfortunate, but it was a much more serious crime if somebody raped a virgin. And those distinctions were built into many state laws across this country, not eliminated, sadly, until very recently. When my state, when our legislators were moving in 1974 to change the law, voices as supposedly liberal as the New York Times, the day of the vote in the legislature, had the lead editorial using the language, it is abhorrent, that's the word they use, it's abhorrent that any man could be convicted of rape solely on the unsupported charge of a woman. And consider that obviously we can convict people of murder on circumstantial evidence. The direct testimony of a woman was not competent. So the unfortunate thing is that even though the law changed and was slow to change, most people aren't even aware of what the word corroboration was, but the overwhelming number of victims who present themselves still today to law enforcement say things like, all there is my word, or all there is my word against his, not even knowing that he doesn't have to participate, he doesn't have to testify under our system. So most victims are still insecure about saying all there is my word. That's all there has to be under our system for any other prosecution to go forward, and it is tested with all the other safeguards we have of direct and cross-examination, rather simply put. The changes that were accomplished in most states in the 60s and in the 70s really were accomplished because of feminist attention to these issues in the 60s. There was no other voice. There were no other lobbying efforts. There was no organized movement within the criminal justice system to change the laws. But finally, feminist attention began to move the legislators, and that was followed by responsible media attention. As I said earlier, there has been very little of that. There has always, and there continues to be sensationalized, inappropriate tabloid attention to these issues. But responsible discussion of the subject was very slow to follow. When the laws changed, we in the system were faced with the problem that we had no experience trying these cases and really didn't know how to get them through the system very well. And so we had three goals when the unit was set up in our office. One was to improve the conviction rate, which would have been impossible not to do. The second was to make the survivors of the crime more comfortable going through the criminal justice system, because the traditional cry was that the victim was assaulted again going through the system. And thirdly was to continue to lobby for legislative reform, which we have done since that time and continue to do today. The other two most significant changes in most states were the passage in the late 70s and early 80s of things called rape shield laws, which protect victims from being cross-examined about sexual history, their personal sexual history, when it's not relevant to the case, and it is not relevant in the overwhelming number of cases that go to trial. That's been a very successful piece of legislation in most states, and usually when I speak, somebody says, well, in every high-profile case that we've read about in the last 5 years, we know everything about the victim's previous sexual history, so that those laws can't work very well. And in fact, with one exception, and the exception is the Glen Ridge case in New Jersey, the high school students who assaulted the young woman who had a mental defect. In every other one of the high-profile publicity cases, the judge kept from the jury, did not allow the defense attorney to question the victims about their prior sexual history. The law worked quite well, but the media, in investigating those cases, disclosed the information about the victim's history that the jury was not even allowed to hear during the course of the trial. So that legislation's been very effective. And one of the other things that's just hard to, hard for me to believe, it was only 10 years ago that New York and many other states eliminated what was called the earnest resistance requirement. In New York, until a decade ago, even in the face of a threat to her life, I mean a gun, a knife, a verbal threat for life, a victim was required to resist her attacker, was not allowed to submit in the face of a weapon. That was considered consent. And our Court of Appeals even held that she must resist to the utmost in order for a case to move forward. And again, only changed 10 years ago in New York. So that's the background, the legal framework in which to go forward, from which to go forward. But I think it's important to understand that we simply couldn't try these cases 20 years ago, and all of the work that's been done is very, very new. And I will go on to tell you what the details are. The range of cases that we see, and this is true in this city as well, I mean any large urban area, the range of cases is, I think, shockingly extreme. Our youngest cases involve infants who are several months of age. They are obviously too young to speak. We don't have them testifying to what happened, but the testimony is in the form of medical evidence, usually, that their bodies bear either internal injuries sustained during sexual assaults or sexually transmitted diseases that the doctors will testify could not have been transmitted in any other way. And so we have over 1,500 cases a year in Manhattan, which are investigations that involve infants and children under the age of 13. The bulk of the population, the greatest at-risk population of victims, and this is pretty even nationally, are young women between the ages of 14 and 45. But then we see many, many victims who are not only middle-aged women, but very many elderly victims, women who are in their 80s and 90s, who don't see themselves as the objects of somebody's sexual interest, but really speak to the pathology of many of the offenders. When I left for the airport this morning, I mean, to give you an idea of the variety, our arrests included last night a 72-year-old lawyer, an immigration lawyer who was accused of assaulting a young illegal alien who was in his office for immigration assistance, and who saved the evidence from the oral sodomy in a tissue that we assume we will be able to match to him by genetic coding when we do the testing. And the other case this morning, but when I left the office at noon, a man was arrested in one of our city hospitals. He is in the hospital because he has TB and AIDS. He was found by a doctor having intercourse on top of a woman's body. She is hospitalized with AIDS and TB, only she's on a respirator and not conscious. And the doctor entered her room and found this other man on top of her body. What was his statement as he was lifted from her body? "I know her. It's all right, I know her." Okay, not conscious on a respirator. So the range of cases, as long as I've been doing this, I would say never ceases to be startling and shocking. We break them down even further in law enforcement in categories that I'm sure you're as familiar with as I, but that in law enforcement that we call stranger rapes are obviously the cases in which the victim and offender did not know each other before the attack occurred. These are sudden, unexpected attacks by strangers. And these are the cases where most often the offender is armed or threatens the life of the victim verbally. These are the cases, and as traumatic, obviously, as the attack is to the survivor of the crime, these are the cases that now do extraordinarily well in the criminal justice system. So I am not minimizing the trauma to the victim. The most important thing is obviously that she survives the attack. But these are the cases that we have learned to investigate well and prosecute well. And all over the country, these are the cases where the conviction rate should be higher than 90%, whatever the community is. And there are a number of reasons for that. The identification of an assailant in a rape case should be better, should be more reliable than the identification of any other kind of criminal. Every town and city in this country has mugging cases, and most muggings occur in less than 3 to 5 minutes, where the victim and offender may be face to face. He demands money or property, and it's passed over. That victim is often able to identify, sometimes not, but those who can look through mugshots, pick out suspects, and suspects are brought to lineups days, weeks, months later, and many victims make identifications which hold up before juries. Rarely does a sexual assault last less than 15 or 20 minutes. And usually when the offender, especially in a stranger rape, has the victim somewhere that she's not likely to be found, whether it's in a burglary of her home or on a rooftop or in a park or in a stairwell, that assault will last for a half hour or an hour or several hours. And that victim will have, whether she's aware of it or not, whether she can articulate it or not when she's first interviewed, she has an enormous amount of information absorbed through all of her senses that we train investigators to probe for and be able to recover. And we as prosecutors, we are trained to be able to convince the jury that her ability to recognize, to describe, to identify an attacker is better than any other victim of a crime because of that lengthier exposure, because of the intimacy of the contact, and because of the opportunity that she's had to view the assailant. There are always, there are parts of the bodies of the offenders, for example, that these victims may even have seen that you don't see during a bank robbery. We often get victims who can describe abdominal surgical scars on an offender's body or legs or thighs, distinctive underwear, tattoos, birthmarks. The story I tell in the book, that's the most extreme version I ever had, which is a little comic relief, was a woman who did not, on first being questioned, offer the information, and she was rather embarrassed, and on the second, more detailed questioning by the detective, said that she had been embarrassed to look at her offender, but she was quite sure that on his penis was a tattoo, and she thought that the tattoo was of a spider. And eventually she looked through mug shots, just facial shots, and she identified weeks later an assailant. And he was picked up and he was placed in a police lineup. And she and I stood in one room with the detective and the suspect and 5 other men. 6 men stood on the other side of a mirror, or rather a two-way window, so that she can see the offenders and suspects rather, and they cannot, of course, see her. And the men were fully dressed, and she identified number 4 as her attacker. And while she and I waited in another room, the detectives went in, and all 6 men were asked to drop their pants. Number 4 indeed had a scorpion tattooed on his penis. We photographed that. When he went to court and had a lawyer assigned to him, there was no other defense that he had offered. The second police report made months before the lineup had detailed the description, this very distinctive marking on his body. And his attorney ended up pleading him guilty to the charge because he did not have an alibi, he didn't have a ringer, he didn't have anybody else to bring in with similar markings. It was not a cheap plea bargain, there was no lesser charge. He didn't have a defense to that identification. And that's a rather extreme example, but it is not that unusual in a rape case that there is something distinctive about the offender that victim is likely to have seen. So that's why, and we've made so much progress with those cases for another reason. But the even better news in that category is the work that's been done with DNA technology or genetic fingerprinting. And when there is body fluid left in the victim's body or on her bed clothing or on her clothing, the police take that to the laboratory and it's analyzed and a genetic code is developed. The DNA from that substance is developed. And as you may be aware, that code is unique to the individual from whom that body fluid came. And whether he's caught the next day or the next month or 10 years later, we get a blood sample, we get a court order to take his blood and develop the genetic code of the suspect. If it matches, indeed, he is the individual who committed the crime. If it eliminates him, we let him go. The only case in which it has failed us recently was an awful case in Manhattan last summer in which a woman was raped by her stepson, who was 16, who then slit her throat in an effort to kill her. And she happened by chance to survive the attack. Unfortunately, he was an identical twin, and she didn't know which of the two stepsons had come to the apartment and attacked her. And because identical twins develop from the same egg, they are the only individuals who have exactly the same DNA or genetic coding. And so we couldn't use that to distinguish between them. And there was a very clever and good police investigation which resulted 2 weeks ago in the conviction of the evil twin, we think. But the good news about that, and I'm making light of a very serious subject, is that with these advances, and the best result is that the survivors of these crimes are often spared having to testify at all in a courtroom because the material and the evidence is so overwhelming often in these cases that we don't have to plea bargain, we don't have to give lesser pleas, but we can present evidence and the offender may plead guilty to the charge. If not, and if there is a trial, the trial for stranger rape victims is a much easier experience than it is for acquaintance and date rape victims that I'm going to talk about next. Generally, because as you're well aware, the public is much more empathetic to victims of stranger rape as a rule than to victims of date and acquaintance rape. And the defense in stranger rape cases doesn't blame the victim for her participation in acts. And the victim in a stranger rape case is rarely cross-examined about anything outside of the period of the occurrence of the crime. So for most stranger rape victims who have come from made-for-TV movies to fear the ordeal of a trial, they are very pleasantly surprised to learn that they're rarely on the witness stand in a stranger case for more than an hour. And that the attack is not on their credibility about the occurrence of the event, but whether or not they had the opportunity to recognize and identify an assailant. So that is really the best area of news. Those cases, as I continue to say, do well within the system. The other category of cases, which is, as you know, acquaintance rape, but that's such a terribly overbroad name because it encompasses such an enormous range of relationships. Acquaintance rape cases do not do nearly as well in the criminal justice system. And as traumatic, again, as the occurrence is to the victim, these are the cases in which the victim has a much more difficult time in the courtroom on the witness stand. As I say, they're hard to put in one category because the problems are so different based on the kind of relationships. These encompass obviously everything from the most intimate domestic marital relationships, incest cases, any kind of prior common law relationship, through, of course, and including every kind of acquaintance and date rape, or the campus rape category of cases. God bless you. And even, I have several chapters in the book about professional defendants and relationships. We have many cases that involve medical health care professionals and victims, clergy and victims, teachers and victims. Last night's arrest of a lawyer and his victim. So in each of these subcategories, depending on the kind of relationship, the problems are very different for these victims in going through the system. But they share one general feature, which is, as much as the laws have changed, this is the area of victimization where public attitudes, the people who will wind up on our juries, remain the least the least enlightened. And it's a very obvious fact that the general public thinks that acquaintance rape, and almost every aspect of it, is a less serious crime than stranger rape. Most of us tend to fear stranger rape more for ourselves and our loved ones, and yet all of the statistics, the most recent statistics from the Department of Justice, suggest that more than 85% of victims of rape are attacked by someone known to them, not by strangers. So they are really the overwhelming proportion of what comes into police and prosecutorial agencies, although they have met with varying degrees of success. In terms of one extreme, domestic violence, I don't know how many of you are aware, last year in this country there were more than 100,000 women admitted to hospitals, admitted as patients, inpatients to hospitals, and more than 40,000 others examined in emergency rooms who were victims of domestic violence. And the biggest problem in identifying those victims, and one reason why we know that the numbers are much higher, I don't know if you're aware that most victims of domestic violence, like victims of child abuse, are actually brought to get medical assistance by the attacker. And the reason that happens is that when an injury has been caused and when the attacker knows that the victim needs medical treatment, he wants to control the story. He wants to be able to assure that she tells the healthcare professional that she fell down the flight of stairs, not that that hole in the head is from a baseball bat. So one of the biggest problems we have is training healthcare professionals to isolate in emergency rooms victims of domestic violence from the accuser, from the person who is, or rather from the accused, who has brought her to the hospital so that they can attempt to get an accurate story. Acquaintance and particularly date rape may be of greatest concern to you here, and I'll take your questions as soon as I'm done. Obviously, you're quite familiar with it, and I'm sure those of you who participated in this week's events have discussed it frequently. Among the off-campus views of what is controversial about it, the fact that there are wildly divergent views and theories about how widespread the problem is on college campuses. There seem to be many variables in people's definitions across this country of what constitutes rape and of how the word is defined. There is the enormous problem of trying to handle within campus administrations cases that would be, if charged in a criminal court, the next most serious crime after homicide, and to resolve these issues with administrative campus hearings or disciplinary hearings with administrators, faculty, and students. And although rape is not new on campus, obviously, the variety of administrative responses that I've become familiar with from around the country are quite new. Some of you may have seen the Wall Street Journal, page 1, April 12th, a little over a week ago, the story about college administrations now being sued because of decisions that have been made. And there are lawsuits that are going forward because, for example, in one case, a young man who has been found guilty by a disciplinary proceeding was suspended from the college, and he and his family have sued, claiming that he was denied due process and wasn't represented by an attorney, wasn't allowed to call witnesses. We are getting reports of this kind of thing from all over, from colleges all over the country, and the president of Princeton in the same article said that these campus hearings are amateur events and that we shouldn't be handling matters as serious as allegations of rape, a major felony on college campuses. So that may be something you want to discuss. Obviously, or I would think you're aware that in many instances, part of the reason that juries have such a difficult time with acquaintance rape cases is that they have, victims of acquaintance rape have traditionally been less well met over the years when they have reported these cases. And so acquaintance rape victims are less likely to make an immediate outcry, unlike stranger rape victims. And as they delay in reporting days or weeks before they go to a law enforcement agency, a defense attorney will attack them and attack the victim in court and make the event seem less serious to her. The reason that she didn't report it is because it wasn't a very significant event at the time, and will accuse her of reporting it, of embellishing the story later for a reason that he'll try to suggest to the jury. Additionally, and especially on college campuses, the statistics suggest that in campus rape, At least 70% of the cases involve the use of alcohol or drugs by one of the parties, 30% of the cases by both of the parties. And that is not to say that that means those victims are any more obviously deserving of being assaulted, but clearly in many of the cases it affects the victim's ability to respond to the attack, and in a courtroom it often affects her ability to remember events and to stand up to a vigorous cross-examination if there has been an extensive amount of alcohol or drug intake. I will tell you one anecdotal story from the book that is, lest you think that this is completely grim and overbearing, that is, I think, an example. I like to tell it because it's a story that most people have enjoyed, but it is an example of how we have attempted to be more innovative about this kind of work and to fashion ways to make convictions in the kind of cases which have been most difficult traditionally to prosecute. The case happened in the late 70s, and I think it was the first time that we had really done something extraordinarily creative, and which we continue to do today, but it was the kind of case in which victims were met with the greatest amount of disbelief. We had a young woman who went to a dentist in New York City, he'd been practicing for more than 25 years, had a good reputation. She found him through the Yellow Pages, went for an appointment, and after he had sedated her with anesthesia to do the dental work on her second visit, she recalled coming out of the anesthesia and feeling that she had been molested by him, that he had undressed her, the upper part of her body, and fondled her breasts. So she went home, told her boyfriend, and he didn't believe her, but encouraged her, when she wouldn't give up, to tell her story to a police officer. She went to the local precinct, told a detective who was skeptical, but did what he would never do to a street defendant in a case who he'd just go out and lock up. He went to the dentist's office and said, "Excuse me, but this woman has told a story about you. Can you explain why she might think she'd been molested?" And the dentist pulled out the literature from the drug he claimed he had used and said that the drug, as you could see, had hallucinatory side effects, and she clearly was having sexual fantasies about him. And so the detective closed the case. And to this day, if you know anybody who has reported being molested by a professional, I think there's even greater disbelief attached to that kind of story, sadly, than with any other kind of offender. So the second victim made a similar report with a little more aggravated conduct 2 or 3 months later. And the detective knew that she was hallucinating because he'd already been to the dentist. So he closed that case out. And it was not, he didn't become a little concerned till the third report was made 6 months later, and he brought that case to our office. And the problem that everybody recognized was that there was no way to know what the conduct was and to have it stand up, have a victim's testimony stand up in criminal court, because the effect of the sedation would mean that the victim was vulnerable to cross-examination. She clearly had lost consciousness for some period of time and could not describe what had happened. So we knew that we needed to send an undercover policewoman in, but that we would have to have some way of recording what had happened, or she too would be vulnerable. So our first task, we found a policewoman with an abscessed tooth, and that was very, very hard to do. And we then applied for a court order, and we analogized it to the kind of court order you get in doing a wiretap of an organized crime location. And the analogy was that a wiretap wouldn't be sufficient. We couldn't put a bug in the guy's office because it didn't require any verbalization for him to molest the patients. So we said that we needed to do a legal burglary and videotape the proceedings. In 1977, we were able to get the first court order in the country to do exactly that. And we broke into his office, the detectives broke into his office the night before the undercover second appointment. And in fact, there was an air conditioning duct, a louvered duct, right over the dental chair. The equipment was installed. The detective had very wisely said, "I will let him commit sexual abuse. He can touch my breasts, but it's not going any further than that." So we had to arrange an elaborate system where your boyfriend sat in the waiting room, and we had the video camera hooked to a monitor in the basement so that guys in the basement could simultaneously watch and send the boyfriend in to interrupt when the dentist went beyond the commission of the first crime. So everything went beautifully according to plan. The dentist pulled the tooth, pulled the wrong tooth in his haste to get to her, and As soon as the tooth was out of her mouth, he lifted her out of the dental chair, which none of us had ever anticipated, and the other women either had not had that happen to them or didn't remember it. But he lifted her out of the chair and began to undress her and began to caress her breasts. And he kept taking her further off screen. And so we knew we had the first crime, and we didn't know where he was going with her. And so the detectives were radioed to break in. One of them did, and he very, very calmly lowered her back into the chair. The detective said, "I'm here to arrest you. You're under arrest." "What for?" "Sexual abuse." He said, "Nonsense. I wasn't abusing her. She was in respiratory distress, and I was resuscitating her." And he actually went to trial with this case, a judge ruling at the conclusion of the trial that squeezing her buttocks was not a known means of resuscitating her. And it's just staggering. I mean, you would think that is an unusual case. In that chapter, I thereafter prosecuted 2 other dentists in the 80s who were twin brothers on Park Avenue in Manhattan doing exactly the same thing. And one idiot was arrested. His brother, who watched him leave his office in handcuffs, knew exactly how he had made the arrest. 2 years later, did exactly the same thing and was let out of his office the same way. So it's again, a light example to make the point that we have done some things to make possible prosecution of cases that couldn't have been tried 20 years ago. The exciting breakthroughs are that kind of success and new techniques like DNA. The very troubling things that go on in this category of victimization continue to be the enormous volume of these crimes. April 1st, the New York Times had its annual crime statistics from 1993. Every other category of violent felony in New York City, from murder, armed robbery, arson, every other category decreased. Rape was the only violent crime that continued to increase in number in New York City last year. That's disturbing. The fact that younger and younger offenders are committing more and more violent crimes is disturbing. This week, the 5th anniversary of the attack on the Central Park jogger, also saw, for those of you who follow the New York papers, 5 teenagers who attacked a young woman, a Russian immigrant, who was jogging on Coney Island, on the boardwalk, and beat her at gunpoint, kicked her in the face intentionally so badly so that she would not be able to see to identify them. And these are kids who are 13, 14, 15. So we are seeing all across the country an escalation in violent crimes, sexual violence among them, committed by younger and younger teens. For the overwhelming number of victims, the laws which enable the prosecution of these cases are in place. Criminal prosecutions, there has been exciting work also in civil recovery and victims who are able to sue to get recovery. And what's as disturbing now, as I said at the beginning, is that unfortunately public attitudes about this kind of victimization have not changed. People still tend to see it as a victim-precipitated crime when the victim and her offender know each other. And much of the work that my colleagues and I are trying to do is to change the attitudes that have been so appallingly slow to change. So I thank those of you who came here to listen to this and stay so attentively, and I hope that you have some questions that I can try to answer now. Thank you.
Linda will be happy to take your questions. I just want to say at the start, there's no one who knows any better than a Harvard professor the temptation of being before an open microphone. So, but I do ask that you observe what we so rarely do and keep your question to a question and keep it brief. So, go ahead. We have microphones on either side, so do you want to do this one?
Okay. I'll start to my
Hi,
left.
I read your book on the heels of reading Alice Fox's book, and I was really struck by the contrast between the two books, being New York County and Queens County. I was wondering if you could speak a little bit about how the public attitudes that are lacking in juries also affect some district attorneys' offices, and how that plays out in the prosecution in the politics that you have to deal with in the offices and that kind of thing, because
Okay.
I couldn't get over the differences
Well,
between
there
the
are a
two.
number of reasons for the difference. Alice Vax, for those of you who don't know, was a prosecutor in Queens for 10 years. She wrote a book called Sex Crimes, and her book it doesn't do the history of the laws as mine does. It's really only her personal experience of the 10 years in the office and the cases she worked on. For one thing, she did not have the privilege of working in what I think is the best district attorney's office. I mean, the difference in Bob Morgenthau's office, and I think he's got more integrity than anybody who's ever been a prosecutor in this country, is an extraordinary opportunity. Alice worked for a man named John Santucci, who ran a much more politically influenced office. There is also an extraordinary difference in the two personalities. My book is I would say that Alice has a much more negative view as a person than I do. Mine is a much more upbeat book than Alice's. I think, and the third thing that I would say, in part, that has to color it is she wrote her book after she was fired from the job by the man, Richard Brown, who's now the Queens DA, who's I think, a great guy who fired Alice. And I think there was a lot of unhappiness that played into that aspect of it, which must affect it. But she has been succeeded by a woman who's done, I think, wonderful things in the Queen's office, Marjorie Fisher, who's also just written a very impressive manual for sex crimes prosecutors about the actual tactical things to do. So I think there is a major distinction in the office that she worked under. I think she worked under much more difficult conditions than I did, probably because of the person for whom she worked.
How widespread do you think that happens a lot in other prosecutors' offices? Or?
Sure. I mean, I think that many places across this country have still political offices. I mean, in a lot of there's 61 or 2 counties in New York State, and there are a lot of upstate counties where only 2 or 3 DAs in the office, and they're elected positions, and they're hotly contested, and there are guys who won't take a lot of. Biggest complaint I get from around the country is that in a lot of the politically motivated prosecutors' offices, they won't try acquaintance rape cases because they're not likely to be convictions very often, and the guys who are running on their conviction rate won't do it. I mean, Morgenthau's always taken the high road that try them and lose them, but if you think they should be tried, try them. So I think the political nature of these offices is a problem in many places in this country. Yes. Okay, this is
Hi, my name is Melissa Liazis. I'm a sophomore at Harvard College. I've also started reading your book, and even though I've only gotten about halfway through, it seems that all the cases you've discussed, you've been able to get convictions of the assailants, but I would imagine that doesn't always happen.
Read on. We have a few lists.
So I was just wondering how often you were able to get convictions and what some of your experiences were in being frustrated by not being able to.
Okay. I mean, I say, and I say at several points in the book, I mean, the reason that I wanted to use cases in which women triumph is because there has been so much bad news, and I think it's a very unrealistic picture to paint at this point, because it has changed. We can get an extraordinary number of convictions. As I say, with stranger rape cases, our conviction rate is probably greater than 95% every year, and it should be. But we investigate. We have 22 senior assistants who handle rape cases. We have 8 who do child sexual abuse. We have another dozen who do domestic violence. We have the luxury to train and devote a lot of attention to these cases. In the acquaintance case category, I would say the conviction rate is probably no better than 65% of the cases that go to trial. But we try them. I was telling somebody on the way over here, we tried and lost last week a marital rape case. I mean, the most difficult kind of case to try, in which, but we believed the woman, we believed in her. We knew that it was very, very difficult. We knew, and we told her, and she undertook it with the understanding that the defendant may well not be convicted. She felt that it was very cathartic for her to be able to face him and accuse him in a courtroom. She also knew that he had been 5 times, at other times in his life, charged with rape, and the jury was not allowed to know that. And he had only been convicted once before, but he never took the stand, and so we were never able to cross-examine him about his character and his prior bad acts. So I choose to tell more stories that are difficult cases that we use techniques to enhance the investigation. We do a lot of work with acquaintance and date rape victims where we will make the case better. We will enhance the case before we make an arrest so that that victim has an easier time in court and a greater likelihood of conviction. I think it's just very detrimental and pernicious in this day and age to keep the myth alive that these cases are impossible to prosecute. They're not. And the hardest thing about them is getting people on the juries who still have the archaic notions that you can't be raped by somebody you slept with consensually before, or prostitutes can't be raped. So the examples I use are difficult cases that we have learned to do better. And it's a cry to other offices around. I mean, it can be done. Our techniques can be used anywhere. They don't cost money, but they really mean aggressively believing in and undertaking these investigations. Yes.
Hi. Hello. Thanks again for being here this evening. Recently, the Harvard newspaper, The Crimson, ran an article about a man who was convicted of actually assaulting young male Harvard students and who has now been paroled and resurfaced in the area. I was interested in hearing if you have made any progress in prosecuting cases where men are the victims, and whether you've seen any progress in men actually coming forward, because I know the majority of cases do involve women as victims, but this is also an area that I think needs to be focused on a little bit more.
Very good point. The underreporting of sexual assault by males is an enormous factor in this business. I'm starting in the wrong order. There is a significant amount of male rape, and it is very underreported, and there's more stigma, as you might guess, on the male rape victim, I think, than on traditionally the female rape victim. Men are not supposed to be victims of sexual assault. And so we probably have less than 5% of what comes into the office a year with adult victims who are men. We have many, many, many hundreds of cases with adolescent and child male victims. One of our biggest problems is getting victims of male rape to talk about it and to participate in the system. We had a case last week. What I find interesting about it is usually there is more gratuitous violence above the sexual assault with male victims. There is usually a lot of other physical injury. And so in many respects, the cases like the one we had last week are easier to prove because the element of consent, which is often the date rape defense, is taken out of the ballpark by the presence of other physical injury. So what we have done is we have a number of outreach groups that try and work. Many male victims don't want to deal with the police department. They can, as can anybody, come directly to us, and some of the advocacy groups specialize in male victims, and they work to convince those victims to come to us. And one of the things we do for any victim, man, woman, child, is my colleagues and I will see that victim off the record, explain to them, listen to the story, explain to them what the problems are, if there are problems, explain what the likelihood of conviction is, and let the victim make an informed decision about what he's going to be exposed to or what she'll be exposed to in going through the process. But it's a significant part of the victim. Men are a significant part of the victim population and very hard to get in the system for the most part. Yes.
Hi. My question has to do with understanding rape and why people rape. And in particular, whether or not rape should be viewed as a hate crime against women and prosecuted as a hate crime against women. Particularly in cases of stranger rape, it always seems so analogous to me to a situation where somebody goes out and targets a victim because of their race or ethnicity, but in this case because of their gender, since they certainly have no other relationship to that person. And why isn't that a hate crime? And why shouldn't that be prosecuted as a hate crime?
Well, as you may be aware, the Violence Against Women Act, the so-called Biden bill in Congress, an aspect of it is a proposition to make it a hate crime. I appreciate that view. I don't have any problem with making it a hate crime. I don't think, I mean, it hasn't stopped. I think it's just as important to get the conviction for a B felony whether or not it's prosecuted as a hate crime. I mean, we've often prosecuted bias crimes when there is no other theory of prosecution allowed. I haven't had a case that I could prosecute as a hate crime, but not
Right.
as a felony. So it hasn't stopped me from doing the work, or I don't mean me, but
Do
my,
you sometimes
know,
prosecute them as hate crimes as well?
there is no legislation. We can't.
In
There is
New
no
York, that's
empowering
right.
legislation. But it is new. It is proposed, and it would make it a federal crime. I put that in the category of nice to know. I mean, I'm not belittling it, but I think it's got to go forward as a B felony with the sanctions that we've got now. I mean, that's what we call them in New York, but a very high level of felony with a very extensive prison sentence upon conviction. But I don't know that the legislation is likely, that part of the Violence Against Women Act is likely to pass, and whether or not there's any likelihood of going forward in federal courts with the overwhelming number of these cases.
My question in terms of understanding it, though, too, is in your experience, do you think that men rape because of hatred towards women as a class all the time or some of the time? And because that's what makes it a hate crime, if it's biased towards a class, and then this victim is selected because of her status.
I have been doing this for 22 years, and I wish that I could tell you why men rape. And I can tell you, I mean, my answer would be that certainly some men do it because they hate women and the class of women, and some occasionally men who will make admissions or confessions to us as part of what we do in the Q&A process will say that. I certainly think there are cases where it would be impossible to convict the offender in many of the acquaintance and date categories. The guy will tell you, and there's no way to establish that he's doing what he's doing because he hates women as a class. So I think that, again, when you see the range of cases, the range of reasons why people offend, they are extraordinarily different, and there's been so little work done in understanding why the crime occurs. I mean, the work from the 60s and 70s that breaks it down into power and anger and humiliation, that's fine for a start, but that really doesn't get to the motivation and the distinctions in it. So I think some of those prosecutions would be successful and many would not.
Okay, thanks.
Okay. Yes.
Hi, I'm Polly.
Hi.
My question is about whether or not in prosecuting offenders who are under the age of 18, you run into problems with conflicts with the laws that protect juvenile offenders, and what you see as a helpful change, or if you don't see it as a problem, and what you see would be a way to address that kind of problem.
Fine. Yeah. In most states, 16 puts the offender in the category of being prosecuted as an adult. So it's usually 16 and not 18. In 1977 in New York, we changed what was then seen as a threshold period when more and more violent and armed crimes were being committed by younger and younger juveniles. We were able to begin to prosecute 15 and 14-year-olds for certain violent felonies, murder, rape, armed robbery. And we did that, and it was a rare thing to see them. They were prosecuted in our adult criminal Supreme Court, and the difference was that they were eligible for a much lower sentence in state prison, and they were kept in a juvenile facility until 18, and then if that was not the end of their sentence, then they could serve an adult sentence. A little complicated. And now we're finding just a staggering opening of the floodgates to younger and younger offenders. So the 13, 12, and 11-year-old armed rapists who we have in New York are prosecuted by the Corporation Counsel, the city attorney, and they go to reform school. I mean, not much happens. The Central Park jogger cases, you know, those only one of those assailants was 16. The rest were under 16. And so, although prosecuted as adults, the 14 and 15-year-olds, one of them is already out of jail. So the sentence structure is lower. Now, I think just about in every state, legislators are grappling with the problems of, I mean, many of these kids, they're not committing juvenile offenses. They are murdering, they are raping, they are committing very, very violent crimes. And we have in our state and most others, prisons that simply warehouse these people. And we're going to see them again because there is certainly for rape, very few forms of rehabilitation that are acknowledged to work at this point. And so the solutions are not very satisfactory, and I think every state has some kind of proposed legislation for tackling younger and younger offenders for the more violent crimes. I don't know if that answers. Yes.
Hi, I also read your book and I really enjoyed it. One of the things I noticed was that you express frustration not only at the sheer number of cases every year that occur, but also the high rate of recidivism, as you were just talking about. I was wondering if you could talk about sort of what reforms, particularly in punishment, you think could be a more stringent deterrent to some of the offenders, because even if you can get convictions again, that doesn't really prevent the act.
Absolutely. I mean, it's probably the most frustrating part of the work. I mean, I was optimistic enough when I started doing this work to think that that rehabilitation was a part of the correction system and would work. There is not a stranger rape that occurs where the offender is 20 or over and that he does not have priors for the same thing. I mean, in my, we just had 2 serial rapists arrested in New York. One on March 1st, a man who had raped 8, 10, 13, and 17-year-old children in a housing project in New York over the winter, and the other one who had raped 5 or 6 women in the Stuyvesant Town area of Manhattan. He was arrested April 1st. In each case, the men had recently been released to parole. In each instance, each had been convicted of raping 3 other women. Each had been sentenced to more than 20 years. Each of them served 10 years and was released to parole. We see them again. We will see them again. States, Connecticut and New Jersey, isolate sex offenders in their prison system and attempt to rehabilitate them. In the last 2 years, even the people working in rehabilitation are calling this kind of serial rapist sexual predators, a relatively new term, and acknowledging that there is no known form of rehabilitation that helps these offenders. So there is no deterrence. I mean, when convicted of these serial rapes, I just simply believe that these guys have forfeited their right to walk among us and need to be isolated from society for as long as the law allows. And it's different. There's a lot of work that's being done, experimental with rehabilitation, that some people say seems to be working. There was a wonderful piece in the Village Voice, the front page piece about 3 weeks ago called The Mind of a Rapist, and a reporter spent a week at a facility in Vermont, which is a separate housing facility where attempts are made to rehabilitate rapists. Now, I have to say, and reading the stories, that the rapes, it was like reading a fairy tale version of New York City. I mean, the stories seemed so much less violent and aggressive than most of the cases that we're involved with. And maybe that was just the bucolic setting, but she described that the therapy is the rapist sitting role-playing, and each one relives his own experience, telling how he committed his offense, so that other people could identify for him each of the awful stages of what he'd done. And then they each role play the victims in the case. I mean, this woman almost lost her mind, she said, by the end of the week of watching this. But they claim in that program to have a high degree of success. It's probably about 2 years old, so I don't know how many these guys are out and how long they've been out. But again, it's something that we've come to so late that there really aren't very many forms of rehabilitation that work, and we're seeing the same population. Did I answer? Yeah. I don't know what the question was. I'm sorry. Thank you. But it is the biggest frustration in the business. They'll be back. Yes.
My neighbor is a student at Harvard Divinity School, and we were speaking about this subject, and she said that they were told in lecture that priests or clergy, medical people, dentists, doctors, and police officers, or people in control, or lawyers, were the greatest offenders. Now, my question is that they victimize vulnerable people, and that often these women don't report it, and it eats away at them for years. What about the statute of limitations in New York? And do you know if the Massachusetts laws are the same, or are they as strong as New York laws, or less strong?
The laws in place for prosecuting are as strong in Massachusetts. That's not a problem in backwards order. The statute of limitations in New York and in most states for a felony is a 5-year limit. Now, I'm not sure. Connecticut is one of the states that has changed the statute of limitation for the repressed memory syndrome, for allowing the prosecution of victims who are claiming that they are now recalling in therapy that...
I did mean adult women, young women.
I'm sorry, you mean?
I do mean young women, not children.
Okay, well, there's a 5-year statute of limitation in most states for the prosecution of felonies. You can prosecute any time within 5 years after the occurrence of the crime.
Can I ask one small
Sure.
question? Among my woman friends who range from 70 down to some teenage girls, they believe that the portrayal of women on television and violence on television has led to children committing these crimes. And do you have an opinion on that?
I know a lot of people think that and feel that. I've never seen, I mean, I assume that that all of the violence on television and all of the attitudinal expressions of or portrayals of women help create certain attitudes in young men and in young offenders, and perhaps numb them to some of the responsive women. I don't attribute a lot of the occurrence of the crime to what's viewed on television.
Thank you.
Were you waiting in the queue there? No, the woman behind you.
Yeah.
Okay, so we have a queue problem here. Go ahead.
Okay.
Go ahead to the lady.
Okay.
Oh, I'm
The
sorry.
thing is, you walked in front of me. It's not a big deal. We're supposed to be asserting ourselves. I was wondering whether you knew much about the Michaels case, the woman who's just been released, and what you thought about that, and what you all do to ensure when you do have 3, 4, or 5-year-old kids, how you make sure that the defense cannot say you led these children, you hypnotized these kids.
Okay. Some of you may have seen 60 Minutes Sunday night, the Morley Safer piece about a young woman named Kelly Michaels, who was a daycare worker in New Jersey, who was convicted of molesting a number of children, served close to 5 years of her sentence, and the Court of Appeals in New Jersey reversed on appeal, and she's out and was about to be retried. I first became aware of the piece, of the case, not knowing anything about it at the time, but there was a brilliant article in Harper's by a woman named Dorothy Rabinowitz, and then I began to hear from professionals about the case. I think it is the most egregious example of the work that the therapists did with the children. One of the biggest problems in child sexual abuse cases, and I think they are far and away the most difficult category of all the subcategories to investigate, is quite simply the problem that children are suggestible. It is, anybody who works in child psych will tell you, many of them tell the truth, and when children describe sexual assault and don't have the language or knowledge of the acts, you would get chills to hear the graphic descriptions, and you know those children have been there. In this case, before prosecutors ever got to it, the children were seen by counselors, and what was never turned over to the defense in a really egregious display of prosecutorial misconduct, I think, were the tapes. There were tapes done of the interviews, and a portion of one tape was played in the 60 Minutes thing where the counselor kept saying to the child, did Kelly ever touch you? No. Did Kelly ever put a fork inside? I mean, there were awful kinds of abuse. She was supposed to have put forks and knives in their orifices, and there was no medical evidence to support any of that, which there usually is when objects have been inserted in children. And 20 times the kids would say no, and on the 21st interview, when the questions were asked in a different way, the kids would say, yes, she abused me. And you have to turn over to the defense every statement that a witness has ever made. So if a witness has said 20 times, no, I was not the victim of a crime, you can't go to trial without the defense knowing that, and just present as a prosecutor the one time that the child said, all right, already, yes, this happened. The Court of Appeals, it's one of the strongest opinions I have ever read in a court case, just really chastises a mild word, was livid with, I'm trying to think of a tasteful way to say, I mean, they excoriated the counselors and the prosecutors for the nature of the investigation. And that opinion, written at least 3 years ago, created entire new guidelines for those offices that weren't doing it. I mean, we have to audio tape, and if we can videotape, all of the, certainly audio tape, all of the investigative sessions as they occur in stages, and all of that has to be turned over to the defense. Much of the time, kids, like adults, are consistent with normal inconsistencies, minor variations, in every telling of the story. In this case, they were not, and there was really, I think, extraordinary room for doubt. And on the basis of the Rabinowitz piece 4 or 5 years ago and the very detailed court opinion, my gut would be that she was not guilty. But the prosecutors claim they're going to attempt to retry it.
Thank you.
Okay. Yes.
You mentioned the fact that a lot of campus-wide rape cases are dealt with within the schools. I was wondering what your opinions on that were in general, and also if these cases had ever been taken and tried again in a court of law, or if they could be tried again in a court of law.
Okay. Yeah, it's... I mean, I firmly believe that if somebody has been the victim of a sexual assault, it should be prosecuted in a court of law. And I understand all of the variables, all the reasons, some emotional, that often victims choose not to do that. We have quite a few campuses in Manhattan, so we have a lot of survivors and victims who come to us. We work closely with the advocacy groups and try to bring into the system those who want to go forward. Not everyone chooses to, and not every case would be successful if they were to choose to. I think it's a very difficult undertaking to try these cases in a pure disciplinary proceeding, unless they are simply, and I'm not minimizing the conduct, violations of a school code and not criminal conduct. And in some cases, that's what the accusation is, and that's fine. But I think it's a very difficult undertaking. I think you're going to see more and more and more lawsuits when these cases, when there is no due process, when a guy doesn't have a lawyer present, when a victim doesn't have a lawyer presenting her case. And so I think that's a dangerous undertaking. And yes, I have seen cases that have had a disciplinary finding and then a victim who's chosen to go to criminal court. And I've seen it done the other way too. Then the disciplinary proceeding is much easier. But it's all relatively new. I mean, 10 years ago, I don't think I had one phone call a year from a college campus, and now we get them from all over the country. Yes.
Could you talk about some of the defense attorneys you've encountered in your 20 years of work? Who are some of the sleaziest ones, and who are some of the ones with the most integrity? I mean, if you think there are any with any integrity.
Oh, of course there are.
And why in both cases?
Okay. Well, certainly on videotape, I will not name names of the sleazy ones. You know, the defense bar is as varied as prosecutors. I mean, I'd like to think all prosecutors were, you know, great lawyers and had wonderful integrity, and that's not always the case. We do a lot of work with the Legal Aid Society, which is our public defender's office in New York. I have worked against some wonderful lawyers in the Legal Aid Society, and those who are my peers. I mean, the story I tell in the book about, which is sort of the background case about a serial rapist called the Midtown Rapist who I prosecuted. He was represented by a colleague of mine who's been in legal aid for as long as I've been in the DA's office, Jeff Abrams. He's got a much harder job in a way. I mean, when you're that senior in a public defender's office, you get the worst criminals, the career criminals, the guys who have got 6, 8, and 10 felony convictions, the strongest cases against them, and it can be very demoralizing. I mean, it's not the made-for-TV movie where you're representing the guy who never did anything wrong and getting him off. And Jeff is a gentleman. He was very good to the victims, you know, still representing his client to the utmost, but he didn't put, he was a gentleman to the victims on the witness stand, with the exception, as I tell in the book, of the one victim of the rape who was a lawyer, and he was much harder on her in cross-examination. And when I went to kick him after, you know, what are you doing? He said to me, well, she's a lawyer. She can take it better than the secretary. But there are some fabulous members of the defense, and the private bar as well. There are some fabulous members of the defense bar. There are people on both sides, but so you're asking me, is it there are defense attorneys I wouldn't turn my back to between here and the door? I've had that experience where people tell me lies. And it's the exception because you don't last very long. I mean, you last, but you don't have a very good reputation and nobody wants to work with you if you don't have a fairly decent reputation. So I've worked against some great lawyers who are very decent people, and sometimes it has tried friendships of mine in some of the highly publicized cases where there's enormous pressure over several months. People I have been friendly with and you work on opposite sides of, and the pressures are very high and the emotions are very deep in these cases. And you don't talk to each other for a while, and then you grow up and get over that. But there are all ranges on both sides.
Let's have the two people left standing in the front here ask their questions briefly, and then we'll close up.
Right. I wanted to ask your opinion on statute of limitations. There are a couple of proposals in this state now to extend the statute of limitations from its present either 7 or 10 years to 20 or to eliminate it altogether. And there's a lot of movement towards this, particularly from incest survivors. Mm-hmm. As a prosecutor and also someone who's familiar with this field, what would be your views on such legislative change?
I think that it's appropriate for incest survivors in particular to extend the statute longer than it has been. I think, for example, it's reasonable, since, especially with most victims of incest, of course, if they have been in the care of the person who's been molesting them, they can't make the complaint until they're emancipated.
Let me amend my question. The current law is that the statute of limitation is told on maturity.
Mm-hmm.
So it's after childhood that the, say, 10 years runs.
Right. I just think it's very dangerous. Well, it's almost useless. I don't know so much dangerous to extend it 20 years. I mean, the reality of being able to, it's fine cosmetically if the legislator wants to do that, and if it's helpful to incest victims to be able to report and get some kind of, resolution 20 years later. The likelihood that many of these cases are going to go to trial, the real problems it presents for an accused who can't realistically interpose an alibi defense 18 years after he's told of what's probably going to be in an incest case, not a specific date. It's not like he's going to say, where were you January 13th, 1962? It's going to be, when I was 5, this happened, and I don't know exactly where or when. In New York, our Court of Appeals says we can't even prosecute cases now with child victims unless we can give a specific date, which just happened last year. So, the reality of being able to prosecute these cases that many years later, I think is not strong. And I just don't think it's going to result in a lot of effective prosecutions.
Last question.
My question is about prosecutorial misconduct and the prosecution of the perpetrators of these crimes. If you look at the demographic redistribution of who the prosecutors are in New York, and with the changing young white females, predominantly from second and third tier law schools, predominantly gaining experience for the first time in the legal professions, and with a high propensity to be the bearers and carriers of institutional racism, if not personal racism, of the kind experienced in Canarsie and other places in Brooklyn, New York, which I know very clearly. With this inbuilt bias and hostility toward the predominant number of black and Puerto Ricans accused in the city of New York of these sex crimes, what steps do you take to reduce the tendency to exploit the institutional bias of racism that may be present in these young, untrained, new prosecutors of sex crimes?
Well, I think you're making a couple of assumptions that I wouldn't agree with. I don't know where you get your information about the composition of our legal staff, but they are not primarily white young women from second and third tier law schools. I would take a look at the Manhattan, Bronx, and Brooklyn DA's office. In particular, I can't speak to Queens and Staten Island, which are probably still predominantly white. I would say, secondly, that they are not untrained young women, that nobody gets into these units, nobody starts working on these cases until they have had at least 4, probably 5 years of experience prosecuting and making judgments about violent crimes and violent felonies, because we have such a a senior stable unit, that it's very difficult to get into the unit. I would say, thirdly, that the victim population, not only is the offender population in Manhattan primarily Black and Hispanic, I would agree with that with the demographics, but so is the victim population. I mean, most of these crimes are intraracial, and it is Black on Black, Hispanic on Hispanic. And it is the victims of these crimes coming forward and identifying the offenders. And I have to say, you may have examples of it. I really resist the notion that the prosecutions undertaken by my colleagues are motivated by racial bias.
All right, I will amend for the purposes of this discussion, New York City. But there is a literature, especially at the federal bench level, that does discuss this nature of the young, predominantly white, female, and second and third tier law school graduates who populate the district attorney's office across the nation. So while I will amend that portion of the question, I don't think you addressed the other side of the issue, namely that there is no social control on both the nature, scope, and definition of three known biases of these crimes, prosecution. Overcharging of the alleged perpetrators, all right? That is mixing it up with other things to push a plea bargain. 2, the attempt to take second and third offenders as presumptively guilty oftentimes. And 3, the difficulty of dealing with prosecution, especially in date rapes, all right, that often lead to people making compromising and inconsistent statements that impeach the credibility of the intimate, which oftentimes prosecutors in a new literature that's coming up do not tell the defense about.
Okay. I truly hope, since the things you've said the second time you didn't say the first, that you will read my book and my chapters on false reporting and in the problems of the acquaintance and date rape case. I didn't bring those things up. You're right, there have certainly been, but I identify those and I deal with them very aggressively in this book, and I agree that they can be problems. I don't accept some of your other basic premises. I would say that certainly the history and one of the tragedies of rape prosecutions, as you're well aware, is the crossover crimes, so-called, in the South, the history of whites prosecuting Black men for raping white women.
Yeah, but we have the
and
inverse
the capital
situation.
cases.
That's what I'm addressing to you.
Pardon?
Now. I think we have the inverse situation in a place like New York now, where you have a predominant over-white prosecuting population dealing with a disproportionate Black and Hispanic, and now
Come see our office. It's not.
now,
I mean, we've got a
now
wonderful
immigrants of color, all right, who wind up with a language barrier which even complicate more the cultural meaning of what, in fact, did happen.
You're making a lot of assumptions. I wish you'd come see our office. Okay. Thank you all very much. I appreciate your staying so late.